Hi, everyone. Welcome to everybody coming in. We're just going to give it a few seconds or a minute to allow people to log in, and then we'll begin. Great. Hello, everyone. Welcome to today's webinar reviewing some key developments occurring in Canadian patent law in 2024. My name is Andrea Berenbaum. I'm a principal at Smart & Biggar. I'm joined by my colleagues Ryan DeVries and Mike Scrow, and we are thrilled to be able to share our insights with you today. Thank you so much for joining us. Before we jump into the substantive content, I'd like to start with a few housekeeping details. Our formal presentation will be followed by an open and interactive Q&A session. We will address more specific questions you may have. You are welcome to submit questions at any time during the presentation by clicking on the Q&A panel at the bottom of your screen. We'll try to address as many questions as we can. We will follow up with questions that we do not have time to answer. This webinar is being recorded. After the session, you'll receive an email with a link to the recording along with a PDF copy of the slides. At the end of this webinar, a survey link will pop up, and we'd appreciate it if you could take a moment to share your feedback. Now I will turn it over to Ryan, who will begin with a prosecution update.
Thanks, Andrea. We'll dive right into an update on the Patent Office IT system upgrade. The processing of applications by Canadian Patent Office is one of the points we expect clients will be particularly interested in, and processing was considerably affected in 2024 by a fairly all-encompassing IT system upgrade at CIPO in the summer of 2024. During the update, there was a time window when the IT system was quite unavailable to us, and this affected even our ability to determine the status of a patent application. So you may have experienced this as a time when we were unable to provide you with a definitive status update on a particular application, or when an application was incorrectly listed as abandoned as a result of a delay in processing correspondence. More generally, this resulted in some delay in 2024 in the usual timelines for advancing an application. And some of these issues also continued after the system came back online. However, we're pleased to report that the system update appears to be largely complete, and the backlog of outgoing and incoming correspondence is being dealt with. CIPO's done a great job of dealing with a tricky situation, and we're seeing a restoration. One of the main limits that stood out for me was the sending of notices of allowance, and I think the best indication that a case was allowable for a time seemed to be the lack of correspondence from the Patent Office, particularly for cases in expedited examination streams. I know in my own practice this caused some challenges for applicants negotiating with competitors, but the processing of these notices seems to be back to or close to pre-update levels. Just as kind of a touch point, I saw on Friday that across the firm we received a large number of notices of allowance last week. So hopefully the new systems will serve CIPO well for many years. Turning now to patent term adjustment. Patent term adjustment regulations came into force in Canada. To some extent, this is a 2025 development since they came into force on January 1st of this year. However, since we now have some clarity on what patent term adjustments might be available, I wanted to mention it just briefly. We've published an article recently with more details about the regime, but one thing to note is that it will be fairly different from the regime in the US that most of us are familiar with. I think a recent study found that more than 60% of patents in the US get at least some patent term adjustment, but according to a regulatory note, the Patent Office appears to be estimating that they will receive only comparatively few applications. In very rough numbers, about 100 applications a year, although the Patent Office generally grants about 20,000 patents per year. So this might be due to some of the application requirements, which involve a fee in Canada, or the calculation method, and that's discussed in more detail in the article. Finally, just a quick mention about AI inventorship in Canada. This might be a fairly special interest item, so I'll keep it brief. The Patent Office is currently handling an application that was filed naming an AI as an inventor. The case has been referred to the Patent Appeal Board, and a panel has taken up the matter. The panel set out in a letter to the applicant that the preliminary view is that an investor must be a natural person. A hearing is scheduled for later this month. So with that, I'll turn it back to Andrea.
Great, thanks, Ryan. I will be speaking about some developments in 2024 relating to the patentability of methods of medical treatment. In the current position is in Canadian patent law is that methods of medical treatment are not considered patentable subject matter. Even though the original decision was based on a now repealed section of the Patent Act, this remains the case. It is possible to obtain medical use claims, however. There's several different formats that are acceptable in Canada, including German style, Swiss style, and EPC 2000 style. In the Pharmascience and Janssen case, the Federal Court of Appeal considered distinctions between these forms. Next slide. So how did this case get there? It's an appeal from Janssen and Pharmascience, which related to actions pursuant to subsection 6.1 of the Patented Medicines Notice of Compliance Regulations. In that decision, the federal court found that the claims of the 335 patent, which I'll discuss in greater detail in the next slides, were not obvious for methods of medical treatment. And the federal court declared that making, constructing, using, or selling the drug at issue by Pharmascience in accordance with this abbreviated new drug submissions would infringe the claims of that patent. On appeal, the only ground of invalidity was whether the claims of the 335 patent are invalid because they comprise methods of medical treatment and are therefore unpatentable subject matter. So the 335 patent relates to paliperidone palmitate, and the claims of the patent relate to dosing regimens for paliperidone palmitate. If you've been following Canadian patent law for the past couple decades, you'll see that there's been a fair amount of uncertainty in claims that are medical use claims that have dosing regimens. So this is another decision that relates to this. The federal court categorized the claims of the 335 patent into product claims, which are highlighted in black on this slide, and use claims, which were highlighted in red. In its reasons, the federal court stated that the method of medical treatment analysis is only relevant in respect to the product claims, or sorry, in respect. Can you go back to the last slide? Thanks. The method medical treatment analysis is only relevant in respect of the use claims. So those claims that were highlighted in red on the slide. Next slide. So the claimed dosing regimen involves a first loading dose administered into a particular location on day 1, a second loading dose administered into that location on day 8, plus or minus 2 days, and maintenance doses administered into the deltoid or gluteal muscle monthly, plus or minus 7 days after the second injection. For the use claims, the federal court held that professional skill and judgment would not be required to implement the claimed dosing regimens, as there were no choices in respect to the possible ranges for the dosage amounts, and that any claim elements that involve choice, so the dosing windows around day 8 and monthly doses and injection sites for the maintenance dose, did not have clinical implications. Next slide. On appeal, Pharmascience argued the federal court erred in excluding the product claims from the method of medical treatment analysis and determining patentability on the basis of the so-called dichotomy between fixed and variable dosing regimens. The Federal Court of Appeal affirmed that the claims, so what the federal court categorized as product claims, the EPC 2000 and Swiss styles, the Federal Court of Appeal affirmed that these were product claims and did not define methods of medical treatment. However, the Federal Court of Appeal did not accept Pharmascience's assertion that these claims were actually excluded from the method of medical treatment analysis. In any event, it held that the federal court's method of medical treatment analysis in relation to the use claims would apply equally to the other claims. Next slide. The Federal Court of Appeal also reviewed the current state of the law in respect to methods of medical treatment and held that whether or not a patent claim to a dosing regimen relates to a method of medical treatment cannot be based exclusively on whether its dosing and schedule are fixed or not. The proper inquiry is whether use of the invention, how to use it, not whether to use it, requires exercise of skill and judgment. It was held that the federal court properly recognized the above distinction that there was no legal error in the conclusions relating to choices having no clinical implications. So the current status of this is that Pharmascience's application for leave to appeal to the Supreme Court of Canada has been granted.
I'm going to follow on to Andrea's discussion here with further cases related to the same Janssen patent, but in this case in a different context. So here it's going to be the test for inducing infringement. So the Patent Act provides a patentee with the exclusive right, privilege, and liberty, of making, constructing, and using invention and selling it to others to be used. In an infringement action, there will always be an alleged direct infringer. However, liability is not necessarily limited to the direct infringer only. Another party can be found liable for inducing infringement. So this would be a case where the party does not directly carry out, make, use, construct the claimed invention, but causes another to do so. To establish inducing and to find liability for inducing, it's necessary that, the acts of infringement be completed by a direct infringer. The completion of the acts must be influenced to the point that without the influence, the direct infringement would not have taken place. And the influence must be knowingly exercised by the inducer. Now, this does not mean that they have to know that it's going to be infringed, that their inducing will cause infringement of a patent, but rather that their inducement will cause the direct infringer to carry out the acts which are ultimately determined to be infringement. So Pharmascience and Janssen, this, as I mentioned, this relates to an appeal related to the same Janssen patent discussed by Andrea. At the trial level, the federal court had found that Pharmascience would induce infringement of the patent. Pharmascience's appeal related only to the first prong, that being whether there was indeed, or in the case of a pharmaceutical patent litigated under the PMNOC regulations, whether there would be direct infringement of a patent, and argued that because Janssen sold a particular dose that Pharmascience would not be selling, Janssen provided an implied license to use the entire claimed dosing regimen. So the argument effectively breaks down to, if you sell a component part of a, say, a claimed method, and I use that term loosely here because, of course, as Andrea just mentioned, you cannot claim methods of medical treatment in Canada. But if you use if you sell a component part of a patented combination, we'll say, then you have the purchaser of that component has an implied license to use the claimed combination. This is based on some longstanding jurisprudence about, I think, wound coils that you would use with electrical wires. The federal court rejected the argument, finding that there is no reason to conclude that either Janssen or its customers would have an understanding that the purchase of paliperidone palmitate in a single dose from Janssen included an implied license to use the entire dosing regimen of the product in combinations with other doses that would be obtained from unlicensed sources. I think a corresponding case or a related decision from the Federal Court of Appeal is the Apotex and Janssen decision cited here. This, again, is an appeal from a trial decision where the federal court found, in this case, that Apotex would induce infringement of the same Janssen patent. In contrast to the Pharmascience case, the appeal for Apotex here related only to the second prong, and it's based on the argument that Apotex's acts through the product monograph that would accompany the any dose sold by Apotex would not meet a high threshold required for the second prong of the test. So Apotex characterized this as a but-for test. So but for the acts of Apotex, the infringement would not have occurred. Apotex relied on the fact that its product monograph would essentially be a copy of Janssen's, and because physicians were already aware of Janssen's product monograph and the prescribing practices, there would be no change to what they were doing. They would use Apotex's product or use Janssen's with Apotex's product in the way they had done so in the past. As with the case in the pharma science, the federal court rejected the argument. Here, focusing on what is effectively the exercise of skill and judgment required by the physician to determine whether to prescribe a dosing regimen that would fall within the scope of the claims. The court focused on the fact that the prescribing practices of a physician do not need to be altered because of Apotex's activities for the second prong to be met. What matters is whether the ultimate act of direct infringement occurs because of Apotex's activities. Is a bit of an aside here. I've noted that Apotex had characterized the second prong as a but-for test. There was previous decisions actually by the Federal Court of Appeal last year that I don't think would have gone as far as using this specific language. It really didn't seem to be a significance of the federal court here, who affirmed that they did not take issue with the characterization as a but-for test, but reaffirmed that the language is set out in the test that I noted on a couple slides back. It really is no different than or the characterization really doesn't change the test.
Thanks, Mike. In 2024, the federal court issued an interesting decision on ambiguity. So to start with the Patent Act itself, subsection 27.4 of the Patent Act sets out the requirement that an invention be defined distinctly and in explicit terms in the claims. Generally, this prohibits claims which include terms that are vague or inconsistent with other claim terms, and it's relatively rare for ambiguity to be the basis on which a court finds claims invalid. This is at least in part because claims are interpreted with a mind willing to understand. However, in 2024, we had one of these rare cases, and I think this case emphasizes the dangers of relying on vagueness to expand claim scope. Turning now to the case. Tecna versus AP&C was a federal court decision concerning two of AP&C's patents. These patents were directed to a process of manufacturing powders used in additive manufacturing, so 3D printing, for example. The powders were manufactured in a process that included forming a surface layer, and the surface layer included a native oxide layer and a depletion layer. So importantly, the parties agreed that the term depletion layer was not a term of art, not a term that a person of skill in the art would know. It was one that was created by the inventors, and this left the person of skill in the art to seek the meaning for the term from the patent itself. So the upper portion of figure 3 here suggests a clear arrangement of layers, but in practice, the layers are harder to distinguish. In the primary example discussed, the particle body is formed of titanium, and the depletion layer was formed of titanium with oxygen that was introduced as an additive gas as part of the manufacturing process. And this leads to some difficulties since the oxide layer is also, of course, formed of titanium and oxygen. In this case, the court considered whether the claims with this new term, depletion layer, could be understood by a person of skill in the art. The court set up this decision with a quote concerning the importance of predictability to let others know what does and does not infringe a claim. The court also recognized that ambiguity is a rare grounds for invalidity. The claims are to be interpreted by a person of skill in the art, and further, this person is one who tries to understand the claims. However, in this case, the court ran into some difficulty finding a meaning for the term depletion layer. As I noted earlier, in some respects, the native oxide layer and the depletion layer are very similar, leading to the question, what is a depletion layer, and how does a reader know if they formed a depletion layer as claimed, rather than just a thick native oxide layer, for example? No explicit definition of a depletion layer was given in the patents. The patents did discuss differences between the depletion layer and the native oxide layer, but the discussion was largely framed as a discussion of a theory about why the particles generated by the manufacturing process had improved flowability, and the discussion of the theory was accompanied by statements that the inventors did not want to be bound by the theory. The patents did also provide examples of test results, and the court considered the argument that the test results provided a way to determine what the depletion layer was. However, the court ultimately found that it was not clear from the details provided and the accompanying discussion what a depletion layer was. In the end, after considering both the claims and the description, the court concluded that it's impossible for the skilled reader to know or determine from the description and the associated claims whether or not a powder particle has a depletion layer. So I think this is a cautionary case, certainly. Of note, I think, is that the court stated that there were some claims which did set out explicitly what a depletion layer was for the purpose of those claims, and the court stated that those claims were not ambiguous. In other words, even if the description did not make clear how a depletion layer should be defined or understood, where the inventors committed to a particular definition, that commitment resulted in non-ambiguous claims. Although in this case, the court noted that those claims were not asserted as being infringed. The decision is being appealed, so there might be a further update on this in the future. Back to you, Andrea.
Great, thanks, Ryan. So let's talk about for a few minutes. So this case, Medexus and Accord, was an action for infringement of the 662 patent. Accord had received Health Canada approval to market syringes and injector devices pre-filled with a 50 milligram per milliliter methotrexate solution based on the plate-tip Metoject products. Accord conceded infringement of the 662 patent, but argued that what was referred to as the asserted claims are invalid. The federal court ultimately found the asserted claims were invalid for obviousness and dismissed the action for infringement, granting the counterclaim for declaration of invalidity. But we're talking about this decision today because the parties disagreed on the construction of the term about 50 milligrams per milliliter. Next slide. So this is because that was a feature of the narrowest asserted claim of the 662 patent. Accord argued the term about 50 milligrams per milliliter is ambiguous. As we just heard from Ryan, this is a difficult argument to succeed on, but it was argued in this case. Next slide. Here, the court found that Accord did not meet the burden of establishing the claims were invalid for ambiguity. This was the case, even though the 662 patent doesn't provide a definition for this term. And this was the case, even though the court was of the view that there was no compelling evidence that was brought of what the skilled person would even expect the boundaries of the claims to be. So the court stated that, in conclusion, the defendants have not established that about is incapable of understanding, nor have they established that about 50 milligrams per milliliter cannot provide an unambiguous boundary defining the scope of the monopoly. They have not established that the claims that included this feature or any claims referring to them are invalid for ambiguity because the skilled person, with the assistance of the specification and a mind willing to understand, would be unable to construe the claim term. So the court looked broader than just whether there was a definition for the term about. There was evidence brought relating to additional parts of the specification that could be used in construing that term. Next slide. I think I think including about may prove important. We see objections to this claim quite commonly during the prosecution of a Canadian patent application, particularly in the chemical and life sciences. But certain of such objections can often be overcome through argument and or amendment because including the term about may prove important, and because Canada is a jurisdiction where it is possible to still get claims having that feature. I think this is something that you may consider attempting to retain and want to discuss that with your agent.
I'm going to follow on next with a discussion of a couple decisions related to entitlement to an accounting of profits. So the Patent Act provides multiple potential remedies for patent infringement. This includes reasonable compensation between publication and grant, damages sustained by reason of the infringement. So this may be in the form of a reasonable royalty, or it could be damages that result from lost sales as a result of the infringement. Additionally, there's a possibility of being awarded an accounting of the infringer's profits. So this is to avoid unjust enrichment, and a patentee could be entitled to any profits made by the infringer that are causally attributable to the infringement. Damages in an accounting of profits are available in the alternative. Unlike damages, however, an accounting of profits is an equitable remedy. It's at the discretion of the court. And it may, subsequent jurisprudence to date has established that it may be awarded based on, and these are, an exemplary list of considerations that is non-closed, whether there's been undue delay in commencing or prosecuting the litigation, the patentee's or the infringer's conduct, whether the patentee practiced the invention in Canada, and the complexity of calculating and accounting of profits. So the two decisions that made their way to the Federal Court of Appeal in 2024 arise from two Roe v. Guides decisions in 2022. So the 2022 decisions relate to allegations of infringement brought by Roe v. Against different parties. Roe v. had asserted various claims from 4 patents. The federal court, in the end, found that the asserted claims were either invalid, not infringed, or both invalid and not infringed. This could have ended the matter, but for completion, the federal court also considered Roe v.'s request that if they were to be successful, they receive an accounting of profits. In considering in carrying out a remedial analysis, the court decided that Roe v. would not have been entitled to an accounting of profits in this case, or in these cases, I should say, in both. And I will say ahead of time, I've generalized between the two. There are a lot of similarities. There are also distinctions that you could see if you read the cases separately. But I think these are the common points that arose from both. The court had noted that Roe v. has a reputation of using hardball legal tactics to pressure third parties to license its portfolio. Roe v. also did not send cease and desist letters. Roe v. was never prepared to disclose that what the portfolio actually included, or to reveal a list of patents that it thought were infringed. And Roe v. apparently deliberately delayed the prosecution of some of the patents at issue. So one of the patents granted more than 17 years after the filing date. I believe there was one that also granted 15 years after the fact. Roe v. appealed both of the decisions. They appealed both the invalidity and the remedial portions of the decisions. At the outset, I'll note the Federal Court of Appeal didn't interfere with the federal court's findings regarding obviousness and/or anticipation, but it did take the time to address the remedial analysis. I think importantly, they looked at the conduct of Roe v. and started out with, first, the federal court started from the wrong premise. It should have started from the position that Roe v. would be entitled to an accounting of profits, and it would be necessary to consider whether there was sufficient compelling reasons to deny the remedy, rather than starting from the fact that Roe v. has to establish that they are entitled to the accounting of profits. Beyond this, and looking at some of these specific comments that the federal court raised in relation to Roe v.'s conduct, the federal court clarified, Roe v. did not have an obligation to identify the claims that would have been infringed, and in fact noted that not only are patents publicly available, but at the same time, sometimes it's going to be the alleged infringer who's in a better position to assess whether they are infringing the claims of a granted patent. It is the alleged infringer who is going to be most aware of their own technology. The court also highlighted there's nothing inappropriate per se about a party's staunch defense of its perceived patent rights or adopting a business model of licensing. And further, that Roe v. shouldn't have been faulted for failing to send cease and desist letters. What stood out to myself as someone who prosecutes patents is the federal court's discussion of the delays in the time it took for some of the patents to grant. So first, the court concluded that the federal court's assessment of prosecution's delays was made without evidence about normal practice and delays typically seen before the Patent Office. It also did not assess Roe v.'s motives in prosecuting the patents the way it did. That said, the federal court also did not foreclose the possibility that prosecution delays could be relevant to whether an accounting of profits is available, stating that, as for the length of time that it took Roe v. to prosecute the patents before the Patent Office, I would not completely foreclose the possibility that this sort of delay could be relevant to refusing an accounting of profits. If there were ever a basis to determine that a plaintiff had unclean hands in seeking to extend the prosecution time to allow a defendant to accumulate profits that the plaintiff would then obtain, such conduct could well be found to be so inequitable as to disentitle the plaintiff to an accounting of profits. So it's possible this could come into play later, And I think this is oftentimes people have been following so patent holdup issues. I think this has received a lot of attention in the US. It's not foreclosing the possibility, but it's also saying this was not the case to assess that in. With that, I'll pass this over to a discussion of use of a patent invention by Ryan.
Thanks, Mike. So the next case we'll be looking at is a federal court of appeals case concerning use. Section 42 of the Act states that a patent grants the patentee the exclusive right to use the invention defined in the patent. So on its face, this seems fairly clear. But the case we're looking at was informed by the Supreme Court's comments in the Monsanto case in 2004, when the court commented that deriving a benefit from an invention suggests an infringing use. In 2024, the Federal Court of Appeal considered the question of whether this means that a party uses an invention by exploiting the invention's purpose to derive a benefit, or if it's limited to exploiting the invention itself to derive a benefit. Taking a look at the facts of the case now. The case concerned a patent for a facility for liquefying natural gas. Figure 1 shows an example facility with a floating module, 20, and other components of the facility on shore. Briefly considering the timeline on the next slide here, the court describes a business relationship between the parties during which confidential information was disclosed, including the design of the proposed facility. The business relationship ended around the time that an application for the patent was filed, and predecessor companies of the respondent worked with a third party to prepare an engineering design for a facility. For the purpose of this decision on use, the parties agreed that if the facility and the engineering design was built, it would include all the essential elements of the patent claims. So the engineering design was presented to various third parties, and the predecessor companies to the respondent sought investment or partnership with some of those companies. They also entered into discussions with another party that they ultimately ended up going with, and that discussion did not involve the engineering design, and the project that they worked on was one that was based on a different design. So turning now to the decision, the issue considered was quite focused. The only question was whether using the engineering design amounted to an infringing use. And one important note is that the patentee was not alleging that an infringing facility was built or that an infringing facility was being planned to be built, only that the use of the engineering design amounted to an infringing use. The next slide summarizes the patentee's position. The patentee's position was that the use of the engineering design helped the respondent to show credibility to third parties, to demonstrate that they were aware of and were addressing challenges and advancing potential options for a floating facility. And the patentee argued that this effectively allowed them to secure the deal that they did secure, even if it wasn't based on this particular facility. The patentee took the position that this deprived them of the time-limited monopoly to build market share for their facility, and that they were entitled to that under the patent bargain in return for disclosing their invention. This argument, however, was rejected by the court. The court focused on the claims as defining the protected invention, and the court found that the benefit to which the patentee was entitled was the benefit from exploiting the invention, not all benefits derived from exploiting the invention's purpose. I think the next slide also includes an informative quote from the decision. The court noted that the position taken that the portion of the Monsanto decision discussing who should get the invention was grounded in a discussion of the use of the patented object, and that patented object was not in existence in this case. The court also referred to case law stating that the protection of the patent lies not in the identification of a desirable result, but in teaching one particular means to achieve it. I think this case really highlights the importance of considering what activity a set of claims actually covers and how an infringement action could be brought if a competitor were to take the invention, and that consideration should take place during the drafting, the initial drafting, and during the prosecution especially. At any rate, Steelhead is seeking to appeal the decision to the Supreme Court of Canada, so there might be another update on this in the future. Back to you, Andrea.
Thanks, Ryan. We're going to turn our attention to the next decision, and we're going to highlight that this is the Patented Medicine Prices Review Board in this case. So what is the Patented Medicine Prices Review Board? It's a quasi-judicial body established by the Patent Act. It regulates so-called excessive pricing of patented medicines, and it has jurisdiction where the invention pertains to a medicine. This comes from definition in the Patent Act, and an invention pertains to a medicine if the invention is intended or capable of being used for medicine or for the preparation or production of medicine. In this case, it related to the drug adapalene. It's a retinoid used to treat acne. Galderma markets two products containing adapalene, Differin, which is a 0.1% adapalene. There was two patents that related to it. The latest expired in 2009, and Differin XP, which is a different concentration, 0.3% adapalene. The 237 patent was the one that related to that one, and it lapsed on March 14th, 2016. So Galderma ceased providing information to the board about Differin after the various patents expired. However, in December 19th, 2016 decision, and I've put the concentrations of these products down on these slides to keep them to keep that information in mind. So the board held that the 237 patent, the one that related to the 0.3% adapalene, was capable of being used for Differin, which is the product with 0.1% adapalene. It therefore ordered Galderma to provide pricing information for Differin from 2010 to 2016. Galderma sought judicial review. There was two earlier decisions. The federal court quashed the board's decision. However, on appeal of that decision, the Federal Court of Appeal overturned the decision and remitted back to the board for redetermination on whether the invention of the 237 patent, which it held was the use of a 0.3% concentration of adapalene for treatment of dermatological disorders, pertains to Differin, which is the product that has 0.1% adapalene. In a 2020 redetermination decision, the board held that given in its view, the clinical similarities, the 237 patent, the one where the invention was held to pertain to the use of 0.3% adapalene, still pertains to Differin, and ordered Galderma to provide pricing information for Differin, again, from 2010 to 2016. And Galderma sought judicial review. At the federal court dismissed the application for judicial review, finding that the board was directed to consider the kind of clinical similarities that would support a finding that the invention of a patent was intended or capable of being used for that medicine. The board found significant clinical similarities between Differin XP and Differin, and reasonably concluded that the invention of the 237 patent pertained to or could be used for Differin. Galderma appealed, and in a 2024 decision, the Federal Court of Appeal granted the appeal and set aside the board's order, holding that the 237 patent did not pertain to Differin. Differin was an unpatented medicine, and the 237 patent did not cover it. In its reasons, the Federal Court of Appeals said that the board does not regulate the pricing of unpatented medicines. After all, it's right in the board's name. The board is the Patented Medicine Prices Review Board, not the Patented and Unpatented Medicine Prices Review Board, or the All Medicine Prices Review Board. So on the next slide, we have the reasons why the Federal Court of Appeal felt that the 237 patent didn't pertain to Differin. Galderma was no longer the patentee for Differin, as after patent expiry, it was no longer entitled to the benefit of the invention, which was the lower concentration of adapalene. The 237 patent is a use patent covering the use of 0.3% adapalene. So the invention of that patent cannot be intended or capable of being used for Differin or for the preparation or production of Differin, as Differin does not embody that use. The board does not have the power to review unpatented medicines, even if a patented medicine might be used in its place or if it shares some unpatented properties of the patented medicine. So the Attorney General would need leave from the Supreme Court of Canada to appeal this decision.
I'm going to now close out our, discussion of cases. In some ways, spoiler alert, leading to a discussion where we may be going in 2025. As you can see on the slide, there's a couple 2025 decisions already listed. To talk about the first judicial consideration of the due care standard applied in the context of paying maintenance fees. So in 2019, amendments to the Patent Act and patent rules were made to bring the Patent Law Treaty into force. One of the amendments introduced the requirement to show due care to reinstate an application or a patent that is deemed abandoned or expired for failure to pay a maintenance fee. Before Parliament, Industry Canada had mentioned how there is a applicant or patentee friendly premise to these amendments, because what ends up happening is if a maintenance fee is missed, the patent or CIPO will issue a late notice informing the applicant or the patentee that it is missed and setting a deadline by which they can pay a maintenance fee and a late fee as a right to reinstate the case. However, if that deadline is missed, they must show that the deadline was missed because, despite the due care required by the circumstances having been taken. In practice, what happens is the deadline is missed, the late fee deadline is missed, and the applicant or patentee then has two opportunities to try to convince the Commissioner of Patents that the failure to pay the maintenance fee and, if necessary, the late fee by the deadline occurred despite the due care required by the circumstances. A request will be submitted. The Patent Office will respond, or CIPO will respond with their review and their preliminary decision. I would call this an intent to refuse letter. The patentee or the applicant then has a month to respond with further reasons as to how they exercise the due care required by the circumstances. If the Commissioner of Patents is not convinced and rejects the request, finally, then an applicant or patentee can seek judicial review of a negative decision to the federal court. To date, I actually checked this morning, CIPO has posted, I think it's about 323 final determinations related to due care. It's a fairly exacting standard. Fewer than 15% of the determinations conclude that due care was taken. I will, of course, note that I think there is that filling out process right from the get-go where agents, patentees, applicants were trying to figure out what the standard would be. And because of this, there are a few determinations where, I think on their own, probably not as strong as one may have realized was necessary. So it took close to 5 years, but we got our first decision by the federal court on an application for judicial review in 2024. And I don't know if I can say this any other way, perhaps in typically Canadian fashion, the invention actually related to a Zamboni and to an ice resurfacing machine, such as that which is used on the Rideau Canal. What led to the deemed expiry in this case is fairly easy to state. The patentee and their Canadian agent had a system by which the Canadian agent would provide reminders to the patentee before the due date for a maintenance fee. They were not to proceed to pay the fee unless they had expressed instructions to do so from the patentee. And this had worked well for close to 10 years. However, in 2020, the Canadian agent's correspondence to the patentee was caught by the patentee's spam filter. And so I think there was 4 or 5 letters before the original deadline, 2 or 3 letters after the original deadline. Each case, it went to the spam filter that the patentee did not discover until after the late fee deadline had passed. The patentee submitted a request to reverse the deemed expiry, explaining what had happened. Ultimately, it was refused by the commissioner, who focused on the fact that the patentee and agent hadn't shown that steps were taken to ensure that email remained an effective form of communication between them. The agent did not appear to have, or perhaps did not rely on, a backup mechanism to contact the patentee when they had not received responses to their various correspondence. And the patentee had not shown that they had been independently monitoring or tracking the maintenance fee deadlines. The federal court dismissed the application of judicial review, affirmed the standard applied by SIPO, and this is a standard you would even see if you look at the Manual of Patent Office Practice, where generally what they're assessing is whether the patentee took all measures that a reasonably prudent patentee would have taken, given the particular set of circumstances to avoid the failure. And despite taking those measures, the failure nevertheless occurred. The federal court also, in relation or addressing an argument made by the patentee, clarified that the various forms of guidance provided by SIPO do not create clear, unqualified framework for handling reinstatement requests. So the Patent Office relies on receiving office guidelines of WIPO and has also set out a list in the Manual of Patent Office Practice of specific fact scenarios that may lead to a determination that the due care required by the circumstances was taken, and those which will not. One of the fact scenarios relates to a breakdown in communication. And so the argument was that, while this is a breakdown of communication, there's guidance in the receiving office guidelines suggesting that this could lead to a finding of due care. And the court just highlighted that everything needs to be considered on its own set of facts. The fact that you have a breakdown in communication or a communication issue alone is not sufficient to show that due care was exercised. I had flagged that I'm jumping ahead a little bit to 2025. The appeal in this case to the Federal Court of Appeal was dismissed. The Federal Court of Appeal's reasons largely reflected those of the federal court. In these circumstances, it seemed, or I guess the court took the position that the patentee should have been independently tracking the deadlines, particularly where they had retained the responsibility to provide instructions to the Canadian agent to ensure that maintenance fees were paid. The Canadian agent, where in this circumstances, for 10 years had successfully received replies to each of their reminders, should have reached out, because this was an unusual, not receiving a reply was unusual based on the existing course of conduct. And both parties, because they relied on communication via email, should have taken steps to ensure that communication via email was remaining effective. I will even go a step further now to another 2025 decision, because after having no decision for 5 years, we got a second decision in 2025. I won't go into the specific details here. The court did affirm the standards set out in the previous decision, but I think somewhat significantly also set out a two-stage framework where an applicant or patentee has 2 opportunities to show that the due care required by the circumstances was taken. The first is prior to the original maintenance fee deadline, and the second would be after receiving notice from the Canadian Intellectual Property Office that a maintenance fee was missed. So that being the late fee notice. Provided that due care was taken at either time, an applicant should be reinstated or the deemed expiry of a patent reversed. So this, the test arises, I think, from a statement by the court that you really need to look at the entire course of conduct when assessing whether due care was exercised. I think the concern in the MATCO decision was that because the focus of the patent office, or sorry, of the Canadian Intellectual Property Office was on the fact that, how the maintenance fee was handled may not have been ideal from their view. It perhaps put the focus on the wrong parties. So if you consider the entire course of conduct, you're more likely to ensure that the analysis or a due care analysis remains focused on the necessary actions or lack of action that's taken and the relevant parties. As of, I believe, yesterday, this case has now been appealed. So I suspect we may have further guidance, maybe this time next year when we're doing another one of these discussions.
I think further guidance on that would be great. So that brings us to the Q&A portion of today's presentation. We are happy to answer your questions as they come in. And remember, you can continue to submit your questions using the Q&A panel at the bottom of the screen. So to start with the first question, I think this one here might be a question for me. Referring back to the Steelhead decision concerning use, were there other options open for protecting valuable IP? Actually, yes, I think this is a prime example suggesting the value of other types of IP in parallel with patent protection. In particular, in this case, because of the initial business arrangement between the parties, there was a discussion of confidential information there, and sort of suggesting the applicability of trade secret protection, non-disclosure obligations, and the court also mentioned that that might be an alternative way to sort of seek recourse for the perhaps it could be described almost as the feeling that this party had taken something from the other party and used their labor for their own benefit. So I think bearing that in mind, especially when working with parties that are not necessarily bound as part of your own applicant group, uh, joint ventures, that kind of thing, any kind of protection for confidential information exchange during the initial stage, even before patents are filed, I think is very, very important to keep track of that and potentially use that as a means to protect inventions in parallel with patent protection. Got another question here. Maybe I'll direct this to you, Andrea. With the incoming tariffs, do you expect more litigation from companies infringing on patents to build parts and precursors currently only made in the US?
Oh gosh, I think that one's a little bit outside of my expertise. I'd prefer not to speak to that one today. My focus is on patent prosecution.
I
I
think it
don't
would
know
be,
if you or Mike have any thoughts on that.
again, I think I agree. My practice is more in prosecution, but I think it will be interesting to see how this could potentially shift practices within Canada as well. Manufacturing practices, enforcement practices, whether this will change the types of enforcement actions that people might undertake. But again, yeah, prosecution. Mike, any comments on that?
No, maybe this is the challenge with having 3 prosecutors on the call at the same time. But at the same time, I think it's a great opportunity to offer a plug for our. We have a litigation year in review tomorrow, and I think they may be in a good position to speak to this point more so than we would be.
Mm-hmm. Yeah, I think that's a great point. So unless we have any other questions, I think we will wrap up the presentation. So thank you very much for your presentation, for your participation, and engagement. I've also been asked to mention that when the webinar ends, a survey link will pop up on your screen. So please take a moment to share your feedback. Thank you so much for joining us, and we hope to see you again at our future sessions.